Hello everyone and welcome to this video tutorial in which we're going to be doing some preparation for A-level law contract exams, and today we're going to look at a possible exam question that you could get asked in contract law, specifically on the topic of consideration. So here's our question: discuss the extent to which the courts have been flexible with the requirement of consideration in order to ensure that contracts are enforced. So straight away then we can see that from the phrasing of this question, obviously you're going to need to explain the rules on consideration, but the focus here, the reason it's asking you, have the courts been flexible, it's giving you a clue that we have this overall rule on consideration, which we'll get to, but have the courts been flexible in their approach? Have they created exceptions to that rule? Were the rules being too harsh? You can see I've put this out of 25 marks because that's how much this question would be worth on the EDUCAS Component 3 Exam 3. If you're with a different exam board, don't worry, you can just disregard the marks. Obviously, you can still be asked about consideration whichever exam board you're with, and obviously the rules and the cases are the same regardless of the board. Just be mindful that your marks might be different on your particular exam. So as always then, we're going to look at a suggested answer, and as usual, I've colour-coded this suggested answer to the question to try and make it a bit easier for you to follow. So when we're answering an evaluative question like this that's asking you to discuss an area of law, the examiners are looking for two things. They're looking for you to explain the rules, the principles, the cases, the facts, and also to analyse and evaluate them. So on this answer on the screen, the black are the facts, or assessment objective 1, and the red font is evaluation or assessment objective 3. I've also highlighted cases for you just to make them stand out a little bit. So you should always start by defining whatever it is that the question's asking you about, and we're being asked about consideration. So English law will not enforce a gratuitous or a bare promise, and that's the fundamental underlying general rule for consideration. And then I've sort of analysed that definition, and you can see that's why it's in red, is that the reason we have this rule is that enforceability of contracts is of fundamental importance in ensuring legal certainty and fairness for all parties. So the rule is that consideration must be given to turn a promise into a binding contract. And we've got a definition here from the case of Dunlop and Selfridge, where consideration was defined as, quote, an act of forbearance of one party, or the promise thereof, is the price for which the promise of another is bought, and the promise given for value is enforceable. Now, as usual, that's a judge talking, so it's a bit waffly, so straight away we can make a criticism that that definition is vague, and it therefore gives courts flexibility in defining the enforceability of any promise. Because that definition isn't specifying precisely what you've got to give in exchange. It's just saying the price for which the promise of another is bought. So that phrasing gives the courts flexibility. And you can see that I'm referring back to the question using that term flexibility. However, recently the applicability of consideration has been questioned, which has led some to suggest that it should be abolished. So we're going to go through the rules of consideration then. So the first rule of consideration is that it must be sufficient, but it need not be adequate. And we've got the classic case of Thomas and Thomas here, where the courts found that the £1 nominal payment was sufficient consideration. And another case you might have looked at on this is Chappell and Nestle, where it was held that actually 3 empty chocolate wrappers was sufficient consideration, even though they were actually thrown away when they were received. So to analyse and evaluate those cases, you can see I've turned it to red font here. These cases are showing that generally the court is unwilling to interfere with bad bargains, as parties to a contract are typically free to bargain on whatever terms they wish. And that comes back to the old rule, the classical rule of contract, freedom of contract, that courts generally don't want to interfere in a contract. And if parties decide the value that they want to pay for an item, really it shouldn't be the courts getting involved and saying that's too much, that sofa isn't worth that amount of money. They leave it to the parties to decide. That's freedom of contract. However, that rule has been criticised as being divorced from commercial reality. And it's nice to give an example here, a practical example, to show that you really know the law, you really understand it. So, for example, there seems little difference between an agreement by A to sell a car to B for 10p, which will be an enforceable contract using this consideration rule, and a promise by A to give the car to B, and yet only the first agreement is enforceable. So you can see there the difference that 10p makes using this rule. In one we've got consideration, in another we haven't. But commercially, is there a real distinction between those two situations? Arguably not. So because of that little conflict there, Atiyah has argued that contract law should be about fairness in exchange. So in other words, Atiyah disagrees with these rules that even a nominal payment can be sufficient consideration. Atiyah would say that there should be adequacy of consideration, and if the consideration was grossly inadequate, this could give rise to a strong suspicion of fraud or undue influence, which could justify the court setting the contract aside. So we've dealt with the first rule, we've defined it with our cases, and we've done a critique of it. Let's get on to rule 2. So the second rule is that the consideration must move from the promisee. And you've got the classic case of Tweddle and Atkinson here, where a groom could not enforce an agreement between his father-in-law and his father because he wasn't a party to the agreement and the consideration did not move from him. And this is where there's sort of an overlap between privity of contract and consideration. So in terms of evaluating that rule from that case, we could say that on the one hand, it does seem fair that a third party to a contract can't enforce it. However, it could be said that by preventing this son from being able to enforce the contract, which he was intended to benefit from, that effectively ignored the intentions of the fathers. There's now more flexibility than there was back then in 1861, because we now have the Contracts Rights of Third Parties Act 1999, and you can allow third parties to benefit under a contract to which they've not given consideration for under this Act. So again, I'm referring back to the question, I'm talking about the fact that this Act has allowed the court's flexibility with this rule. The third rule is that existing contractual duty doesn't constitute consideration, Collins and Godfrey, but we could contrast that case with Williams and Roffey, where the Court of Appeal held that performance of an existing contractual duty can constitute valid consideration if it confers practical benefit on the other party. And the judge, Russell LJ, said that the court would take, quote, a pragmatic approach to the true relationship between the parties. So this case of Williams demonstrates that the courts have been flexible with the concept of consideration in order to ensure that contracts can still be enforced. Our fourth rule on consideration is that part payment of a debt is not consideration, and we've got the classic Pinnell's case from the 1600s, where it was held that part payment of a debt can never satisfy the whole debt, and any agreement to accept part payment is unenforceable because there's no consideration. The creditor could always sue for the balance owed, but accepting part payment of a debt through pressure is not consideration, D and C. However, the courts have been flexible with this requirement, and this is where they've created two exceptions. And whenever you've got exceptions to a general rule, that is showing you that the court is being flexible, it's taking a flexible approach to the law. The first exception comes from Hirachand, where it was held that a promise to accept a smaller sum in full satisfaction of the debt will be binding when it's made by a third party. And the second exception is promissory estoppel. And this, if you remember, was created by Lord Denning. And Lord Denning came up with the idea of promissory estoppel to make a promise binding even where there's no consideration. And that comes from the classic case of high trees. And in tool metal manufacturing, it was applied and patent owners were stopped or prevented from going back on their promise to waive the payments in equity. So this rule of promissory estoppel gives the courts flexibility to enforce contracts where it would be unconscionable or where it would be unfair not to. But they have put some restrictions on the doctrine. And some of the restrictions that we've got, you wouldn't need to list all of them, but there must be an existing contractual relationship, there must have been reliance, and it's only a shield and not a sword. And our final rule is that the consideration must not be passed. So in re McArdle, it was held that if the act is performed before the promise is made, then the consideration is past. It was in the past, and the promise is not enforceable. However, again, the courts have shown some flexibility to that rule if there was an understanding that there would be a conferment of some kind of reward, payment or benefit for the act. And you could look at Casey's patent on that. And you quite often see this particular rule cropping up in scenarios on contract law, because quite often you'll have someone who does a job and it looks like they were expecting to be paid, although perhaps there wasn't a specific clear promise on that, and you'd look at whether there was consideration or not. So we're reaching our conclusion here, and if we just scroll back, you can see that what we've done is we've gone through and explained all of the different rules on consideration and evaluated as we've gone. And you can see, because I've used different colours, that we've got a nice balance of black, red throughout the essay. And that's showing you that hopefully you've got a nice balance between facts and evaluation. So in my conclusion, it says, it's clear that the courts have been flexible, again referring back to the question, with the requirement of consideration in order to ensure that contracts are enforced. However, some assert that since any reasonable man is not going to sign a contract that will only benefit the other party, arguably the doctrine of consideration can be considered as outmoded and redundant. I could have also come back to attire here and said that perhaps some other tweaks or reforms could be made to the law regarding whether consideration is adequate or not. So I hope you found that video helpful. I do have some other videos on the channel on contract law that go through the rules on consideration in case you need some help looking at the cases on this.